Hi, folks. You've been told by your family law attorney that you have been subpoenaed to sit for a deposition. What is a deposition? How do you perform well at a deposition? And what are we going to do and not do at your deposition? We're going to talk about that, and we're going to get you ready to go. You can do this. You just need to know what the rules of the deposition are and how the process will work, and we're going to discuss that next. Before we get into the substance, just a quick disclaimer that the Bar Association requires us to give on these cases. I am moving. My lips are moving. I am giving you advice. I'm hopefully giving you some good educational advice. This in no way creates an attorney-client relationship. I encourage you to talk to your attorney about anything I'm covering on this video. And I don't think anybody should be going into complex or any litigation at all without an attorney. So I encourage you to discuss these principles with your counsel. Hopefully it's with an attorney with Quinn Ann Dworkowski. Hi, my name is David Dworkowski. I'm an attorney with Quinn Ann Dworkowski. Quinn Ann Dworkowski is a full-service family law firm in Irvine, California. We cover every aspect of what your family will encounter, from both divorce all the way through probate litigation, death, estate planning. We're a full-service family law firm. I am a certified family law specialist. I am also a certified appellate law specialist. For nearly 40 years now, I have been dedicated to clients that find themselves in difficult situations in life and often find themselves in courtrooms having to litigate or try those difficult circumstances. I have tried over 350 trials, both in federal and in state court, and have dedicated my life to helping people that find themselves in very difficult situations. Every member of our firm is very dedicated to their cause and to their client. And today we're going to talk about something that's called a deposition. The first thing I'd like to discuss with you is what a deposition is. It's a big word. It causes people right away to feel anxious. You get notified, and you sometimes often get served with a deposition subpoena, and you get served with also a deposition request to bring documents to your deposition. So let's stand back for a moment and take a 10,000-mile view of a deposition to talk about what it is and what the purpose of a deposition is. So anytime you're involved in civil litigation, and that can be anything from a lawsuit to a divorce and family law, and that's what we're going to focus on today. Whenever you're involved in civil litigation, there is a whole process called the discovery process. And the discovery process is a fact-finding process where each side gets to learn all the facts that support their case, all the facts underlying the action, and each side gets to get prepared so that they know what the case or the lawsuit, and divorce is a lawsuit. You get to know what the lawsuit is about, and each side has to reveal their facts and what their premise of their theory of their case is. So a deposition is just, think of it as one more discovery tool that will allow your lawyer and you to learn important information from the other side. And likewise, it will allow the other side to gather information from you. Now, there are all forms of discovery, and if you're going through a divorce, particularly a complex divorce, you probably already know what I'm talking about. We have written forms of discovery where the other side tries to learn information through things like interrogatories, requests for admissions, special interrogatories. And what these things are is it's generally paperwork that's sent to your lawyer, and it will be a series of questions and answers that you will work with your lawyer on responding to those things. And for the most part, those kind of things are not anything that you can't handle easily with your lawyer, and your lawyer will have a number of legal objections, and your lawyer will help with you answer those questions. The deposition is not like that. The deposition is where you will go to a law office. You will sit down in a conference room. You will have your lawyer there. The other side will be there. And that lawyer will have an opportunity to ask you up to 7 hours of questions about your case. Very intimidating for many people. The idea that you're going to be cross-examined by a lawyer on any aspect of your case for up to 7 hours. And by the way, you are placed under oath during this cross-examination. And so I want you to think of a deposition as very similar to when you're asked to go into a courtroom and you were in the middle of your trial in a courtroom and you're on the witness stand and you're being asked questions on the witness stand under oath by the other lawyer. A deposition is the exact same thing as that, except there's no judge present at the deposition. So for starters, I want you to think of the deposition as a very important, formal proceeding, just as if you were in a court of law sitting in a witness stand. Okay? Now, the difference between your testimony in a witness stand at trial, if your case were to go that far, and the testimony you're giving at a deposition is at a deposition, you can be asked any question that might lead to relevant information. So I want you to think of a deposition as having a very broad or wide net in terms of what you can be asked about the case. When you get into a courtroom and you're in trial, there's specific rules. We call them the rules of evidence. And those rules of evidence say that lawyers are somewhat limited at what they can ask you in a trial proceeding. It must be relevant evidence, as opposed to a deposition, which is anything that could potentially lead to relevant evidence. So they're different things, and think of a deposition as being very wide scoped, a very wide net, where almost anything the other side wishes to ask you about, they mostly can ask you about that. Now, the purpose of a deposition is for the lawyer to discover anything and everything about the case that they can then later use against you, either in the trial or for purpose of settling the case. So the purpose of a deposition is for a lawyer to go into that deposition and question you at great length about every area of the case that's important to your issue. So, for example, if you're in a case and it's important as to how much a business is worth, if you're dealing with business valuation, and one of the parties owns a business, and they're talking about what the value of that business is, you will be asked all kinds of questions relevant to that topic of the value of that business. Once that lawyer asks you all those questions and discovers all of that information, then that lawyer will read through that transcript. And yes, a transcript is made. A court reporter is taking down the information. And that lawyer will read through that transcript and discover what portions of that transcript the lawyer wants to use in trial against you if you give a different answer at trial than you did at the deposition. So it's a very powerful tool to either move the case towards settlement or win the case at trial. Indeed, in just about every case I handle at Quinn and Dworkowski, every client I have, I do a deposition of the other party because I want to show the other party that we mean business. I want to discover whatever I can. I want to call into question the credibility of the other party. And I want to, as I'm fond of saying around here, strip the bark off the other party so that we bolster our case we expose weaknesses in their case, and we then use those weaknesses to get our client the very best settlement, if that's what our client wants, or get a result at trial because we've exposed the weaknesses in their case at the deposition. And then when we get into the trial, to the extent that witness tries to change their testimony on the witness stand, we have lodged or presented the judge with the deposition testimony, and I get to then ask the witness from the witness stand about their deposition testimony. So I might say, sir, do you remember coming to a deposition at my office? And I'll have that deposition there, and I can confront the witness with the deposition. And then I'll say, do you remember when I asked you a specific question about what your business was worth and what you testified to at the deposition on that subject? Now, today you're changing that story, aren't you, sir? Because today you gave a business valuation far different than the deposition testimony you gave, didn't you, sir? And then I can confront the witness with their deposition testimony that was made under oath, and we call that a prior inconsistent statement, and it causes the judge to see that the testimony the witness gave that day in court was very different from the testimony they gave at their deposition. And why is that so important? Because in law, if a witness changes their testimony, and particularly tries to change their testimony to their benefit at trial, the judge will look at the testimony they previously gave, and it will cause the judge to question. The fancy word we use is call into question the credibility of that witness's testimony. And in family court, as in so many other areas of law, your credibility is crucial to getting the result you need. So we want to what we call impugn the credibility of your spouse or your significant other, the opposing party, and we want to bolster your credibility. And so a deposition ultimately is all about credibility, preserving your credibility for your deposition, and attacking the opposing party's credibility at their deposition. And we're going to attack them in every relevant area of your case. Once we've done that, we're going to order the transcript from that deposition. We're going to summarize that transcript, and literally it's a line-by-line summary, so we know exactly where things are testified to in that deposition. And then we're going to use that deposition at trial or settlement to attack their case. So, very important. What actually happens at a deposition? How do you prepare for a deposition? How do you make sure that deposition goes as well for you as it possibly can? And we're going to move to that. I do want to mention one more thing, though, which is at the deposition, there's a court reporter who's taking down every word of what you say. And so just like in a court of law, there's somebody who's going to take down every word of what's testified to and then make a transcript. And is that transcript that what is then presented in court to the judge? And you don't just hand the judge the transcript, you select out those portions of the transcript that you'll then ask the witness about from the witness stand. And those portions of the transcript get entered into evidence, and so that becomes powerful evidence. We can, if we wish, videotape the deposition, and we sometimes will do that. And then we not only present the written word in a court of law, but we present the video of the deposition. And there's times we want to videotape the deposition and times we don't much care about the video. We don't need a video, but that's something you want to discuss with your lawyer as to whether we should videotape the deposition or just have a court reporter there. Anyway, okay, so you've been served with the notice of deposition. Your lawyer has told you that this is something you must attend, and indeed it is. It's a subpoena, and so think of it just if you were testifying in court. You don't have a choice whether you want to go to that court proceeding. you must go to that court proceeding. You're subpoenaed. And that's also true with a deposition. You are subpoenaed to be at that deposition, and you must attend the deposition. The next thing is typically the subpoena will tell you these are things you must bring to the deposition. And so the subpoena for your deposition will list a number of documents that you must bring to that deposition. And so what I want you to do is sit down with your lawyer and go through those documents that you must bring to the deposition and understand what is being requested for you to bring to the deposition. And it's not really a request, it's a demand under power of subpoena. And make sure that you've taken the time to discuss with your lawyer what documents need to be brought to the deposition so that you don't show up at the deposition and go, oh, I didn't realize I had to bring these documents to the deposition, which I've seen happen over and over again, where the witness never really discussed it with their lawyer, and they show up at a deposition without having produced the documents that were demanded and subpoenaed for them to bring. And that can be problematic. For starters, it can start to make it look like you're hiding something and start to attack your credibility because you didn't bring the required documents to the deposition. The second problem is the attorney from the other side could say, now we're going to issue what's called motions to compel or continue the deposition, and it just looks bad that you didn't comply with the rules and the subpoenas. So make sure you bring the required documents to the deposition. Now, let's talk about getting prepared for the deposition. We have a slide up here about being prepared. What do you want to do prior to your deposition to make sure you're prepared for your deposition? I always tell my clients that it's a good idea to familiarize yourself with any of the pleadings in the case, particularly those pleadings that you signed a declaration under oath. So in family law, as anybody who goes through a family law case knows, we have a lot of declarations that the parties sign, and those declarations are under oath. They're just as if you're testifying in a court of law or at a deposition. They're under oath statements that you've made, and you've signed them under penalty of perjury. And so those declarations in a court of law are very important because they are evidence, and they are as if you testified to it from a witness stand, and they have the same import for a judge as if that's testimony you gave under oath in court or at a deposition. So I tell my clients, go and look at the declarations you signed in this case and make sure you're familiar with all of your prior statements, particularly those statements you made under oath. Why is that so important? You're almost certainly going to be asked about those declarations at your deposition. So lawyers are almost certainly going to say to you, you filed a declaration back in April, didn't you, ma'am? And you read that declaration prior to signing it, didn't you, ma'am? Let me ask you about the details of what you signed in that declaration. So you know those questions are coming. You know you're going to be asked about your under oath declarations. So by all means, you want to familiarize yourself with those declarations and what you signed under oath, because you're going to be asked about that. You'll be presented with your declaration. So the lawyer asking you will give you a copy of the declaration, and you can review the declaration before answering, and indeed you should. But you don't want the declaration to be something you're not familiar with, so that you're looking at your own declaration at the deposition and you're no longer remembering what you put in that declaration, because that lawyer is going to be firing questions at you about that declaration. And sometimes these declarations are written months or even years in advance of the deposition. So make sure you take the time to review any and all declarations that you filed on the case that you're going to be asked about at the deposition. Now, sometimes people, in preparing for the deposition, will start reviewing other things. I've had clients go and keep notes along the way, or keep a diary along the way, or keep a calendar of events along the way. And prior to the deposition, they'll go and review those things to familiarize yourself and recall what the facts were that may have happened a long time ago. And here we want to be careful, because at the deposition, a lawyer almost certainly will ask you, what did you review today prior to coming to the deposition? The rules say that anything you reviewed, a lawyer is allowed to have a copy of. So if you're saying, I reviewed the pleading I filed back in February, where I had a declaration and my lawyer filed this pleading and I reviewed my declaration, that's safe. The lawyer already has that declaration, and you're not revealing anything to the lawyer when you say, I reviewed my declaration. But let's say that you say, I kept a journal, and along the way, I would write things in my journal about the case, about what's going on in the case, about, let's say it's a custody matter, and you say, I wrote things down about when the kids told me this, or when the exchange took place, or times that the custody matter wasn't going the way it was supposed to go. If you've kept notes or a journal or a calendar, anything like that along the duration of the case, the other side has the absolute right to discover that information and to review it at your deposition. So anything you say at your deposition that you reviewed prior to the deposition, you can absolutely be certain that lawyer is going to say, and I would like you to produce that to me. And you may say, I don't have it. It's a calendar or a ledger that I left at home. And the lawyer's going to say, I'm asking you to produce that to us in the next week or 2 or 3. And if you don't produce it, we're going to subpoena it, and the judge is going to require you to produce it. So what's the lesson we learn here? Be very careful when you're going into a deposition and you're being asked, what did you review in preparation of this deposition, that you have taken the time to discuss this with your lawyer ahead of time, and you've taken the time to be very careful what you're going to review for your preparation of the deposition, so that you don't end up having to provide additional information to the other side that you might not have wanted them to know about. So we have ethical rules here, and you're going to want to talk that with your lawyer because you're compelled to produce certain things. But we want to be very careful in this area when you're referring to things you reviewed prior to your deposition, unless it's pleadings and declarations and things like that the other side already has. So now we have prepared for our deposition. We have talked to our attorney about areas that we might have problems with at our deposition. Every case has some problem areas, some things that you don't feel as comfortable about. We know we're likely to be questioned about those things. So we want to take the time in our preparation to talk to our lawyer. Here is a sensitive area that I'm concerned about. How shall I answer these particular questions? So we want to, in our preparation, be talking to our lawyer about those sensitive areas and review the proper documents. Don't review other documents. And now we're ready for our deposition. Okay. Typically, the deposition is going to be done. If it's your deposition and the other side has subpoenaed you, you have to show up at the other side's law office. So when you're deposing the other party, that deposition will be done at your lawyer's office. But when the other party is deposing you, that will be done at their law office. Now, more and more post-COVID, depositions are being done by Zoom, and so your deposition might be remote. I'm not a big fan of allowing people to be remote when I'm deposing them. So our depositions are almost always where the other party needs to come to our law office, and I'm going to ask them up to 7 hours of questions at the law office. I feel that it's far more effective to judge people's credibility, watch their facial expressions, watch how they're acting, watch if their hand is shaking in a certain area. That can be done far better in person than over a Zoom video. So at Quinn and Dworkowski, our depositions are done in person, but that's something you're going to want to talk to your attorney about because your deposition may well be a remote deposition. All right, for purposes of our video, we're going to assume you're actually at the deposition, but even if you're not at it, these are questions that will be asked of you remotely. So you come to your deposition, and the first thing that's going to happen is the court reporter is going to swear you in, just like in a court of law where you are under oath. At the deposition, you are going to be sworn in, and you're going to be told that you have to tell the truth at this deposition, and you're under oath. And so one of the things we know is in the United States, courts take being under oath very seriously. In fact, it is a felony in California to give false testimony under oath. There's a word for that called perjury. And if you give false testimony on a material or important point of the case, that actually can be charged in California as a felony under perjury sections of the Penal Code. So the duty to tell the truth at the deposition is taken very seriously by the courts. So the first thing the person who's asking you questions is going to ask you about is they're going to say, there's certain rules at the deposition that we follow. So I want you to be aware of those rules, and let me tell you those rules before we begin the deposition. You're going to be told things like, please pause before you answer the question so that you don't overlap with the court reporter, so that your answer and the lawyer's questioning don't overlap each other, or the court reporter can't take that down. You're going to be told that you shouldn't guess at a certain answer, that you're entitled to give your best estimate, but that you shouldn't guess at an answer. You're going to be told that the answers you give can be used in a court of law someday, so that you shouldn't just speculate, or if you don't know the answer, you shouldn't just say something you don't know, because the answers you give are very important, and they're going to be used in a court of law, as we discussed earlier. I always like to tell witnesses, let me give you the difference between a guess and an estimate, because I'm entitled to your best estimate. If I were to ask you the size of this conference table right now, you would say, you'd look at the conference table and give me your best estimate of what the size of this table is. But if I asked you about the size of the table in my office, you haven't seen that table, and that would just be a guess. So I'll say, do you understand the difference between a guess and an estimate? You'll be asked whether or not you've ever testified previously at a deposition, or whether it's the first time you've taken a deposition. You'll ask whether you had a good night's sleep, whether you're under any medications, whether there's anything about the situation that would mean the lawyer can't get your best estimate at the deposition. So those are all the kind of foundational questions that you're going to be asked prior to the lawyer asking any substantive questions about your testimony, prior to the lawyer really drilling down and getting into the substantive questions. You're going to be asked the general questions that I like to call the ground rules of the deposition. Now the lawyer's going to start asking you specific questions about your testimony. Once the ground rules are covered, now the lawyer's going to start asking you specific test questions that are specifically geared to learning information about important aspects of your case. And it's very common that the lawyer will present a document to you. For example, it might be a prior declaration you filed in the case where you discussed some aspect about the case and you filed a paragraph by paragraph. Typically, your lawyer has prepared it, but you've reviewed it and you've signed it, and that is your testimony on that answer. So very often, you will be presented with that document at your deposition. So what do we want to do when that comes up? The first thing we want to do is slow down. We want to read the document to ourselves, and our lawyer should have a copy of the document, so the other attorney should be giving you 2 copies of the document, one for you and one for your lawyer. And you want to take your time and look at that document and familiarize yourself with that document before you answer one question from the lawyer about that document. And by the way, it's very often the case at a deposition I'm attending with my client that the lawyer will hand us a document and then immediately start breaking into questions about the document. And when that happens, your lawyer wants to object and say, we've just been given the document. We're not going to answer a question about this document till we've had a chance to look at the document and familiarize ourselves with what is the content of the document before we answer one question about it. Now, many times you'll be very familiar with the document. And if you did what I suggested you do, which is review important documents that you've signed or filed, you'll know the document. So you won't need a lot of time to understand what's in the document, but you certainly want to take whatever time you need to review the document. Okay, so you've reviewed the document, and now the lawyer's going to ask you questions about what's contained in the document. And the first thing I would ask you to do, and we ask all of our clients to do, is take your time and make sure you've listened to the particulars of the question you've been asked. Now, I know that sounds like a fundamental thing and something that would be understood by everyone, but the truth of the matter is often in our day-to-day lives, we don't take time to answer a question, and we say something that maybe we didn't think out our answer and we regret saying, and many times in day-to-day life, that doesn't really matter. But remember, we're now giving testimony that can be used against us in a court of law. So we want to slow down and we want to give an answer to that question that's responsive to that question. So what do I mean by that? If you're asked a question at a deposition that calls for a yes or no answer, then you want to answer yes or no and leave it at that. If the question is, yesterday, were you driving on the 405 at 5 o'clock at night? That is a question that calls for a yes or no answer. So I don't want to say, yes, I was, and I was with my sister Ruth while I was driving, because now I went beyond the yes or no. I volunteered that I was with my sister Ruth, and you can bet that lawyer's going to ask you all kinds of questions about your sister Ruth that you volunteered. So, rule to know, if you volunteer more than you were required to with that answer, you will certainly cause the lawyer to ask you additional questions about what you volunteered. So be very precise with your answer. Sometimes people say to me, is it okay to say, I don't recall? And the answer is, an I don't recall is generally a very acceptable answer. But even here, we have to be careful, because if you're saying, I don't recall, to something you should reasonably recall, then the I don't recall can be a very damaging answer. Because if you say to me, I don't recall, I'm going to say to you, that's interesting. When you filed your declaration, you recalled all about that. And didn't you say in your declaration that the answer was this? And the answer was very specific to you and you were very aware of the facts and circumstances at that time. And how is it you're not recalling it today? And so let me let you look at your declaration. Let me let you refresh your recollection, because I intend to ask you all kinds of questions about this area. And if you insist that I don't recall, and that starts to look like what we call a feigned misrecollection, then under the evidence code, a judge is entitled, or a trier of fact, a jury or a judge, is entitled to conclude that you have feigned the misrecollection and you're not recalling because it's convenient for you not to recall. And why is that damaging? Because that affects your credibility. And if your credibility is diminished, if your credibility is what we call impugned, then you're not going to get the result you want. So, is I don't recall a proper answer? Sure, under certain circumstances that one would reasonably think you wouldn't recall, then I don't recall is a perfectly acceptable answer. But if someone said to you, what did you have for breakfast this morning? And let's say that was relevant. What did you have for breakfast this morning, ma'am? I don't recall. Ma'am, didn't you just eat 2 hours ago? How is it you can't recall what you had to eat 2 hours ago? And they're going to drill down on you, and they're going to make it look like you're lying about the fact you don't recall. So, 3 answers. Yes, no, I don't recall. They're all acceptable answers at a deposition, but we have to remember they're in context, and we don't want to pick one of those answers if it would cause someone to think that answer doesn't comport with what we would reasonably expect under these circumstances. I hope that's clear. So even those kind of answers need to be thought out. But one of the rules is we're not going to volunteer things if we don't have to volunteer things. Do not bring documents to the deposition. Okay. I want you to discuss that with your attorney. When I say do not bring documents to the deposition, we do have to bring those documents to the deposition that we were compelled to bring because they issued a subpoena, a notice of a subpoena, for us to bring certain documents to the deposition. So those are documents that you would typically give your lawyer ahead of time, and your lawyer will then bring those documents to the deposition and get those documents to the other side. But by this slide, what I'm talking about is I don't want to bring things to the deposition that I wasn't asked to bring. And those could be things like my notes or other documents that I may have had that are somehow not in evidence in the case, but maybe related. If I bring those documents to the deposition and a lawyer sees that I'm referring to those documents, then almost certainly I'm going to be compelled to show those documents to the other side. So generally, I tell my clients, other than the documents we are compelled to bring, I do not want you bringing your notes to the deposition. I do not want you bringing the journal you've been keeping or the calendar you've been keeping or the separate ledger you may have kept where you talked about monies that were given or moved. I want you to be very careful and not go bringing those things to the deposition, because if a lawyer sees you have that stuff or referred to those things, almost certainly you're going to be required to turn that information over. And we don't want to be volunteering things to the other side that we may not have been compelled to produce. Okay? So let's talk about we're in the deposition and our lawyer is objecting along the way to questions that are being asked. And this can be very confusing for witnesses. So let's talk about what that means. And here's the way I want you to be thinking about objections and the way it works. Depositions are going to be, as we discussed, used in trial as to show prior testimony you gave on a case. In trial, there are evidentiary rules. In other words, not everything that a person says can be used in trial. Sometimes things are, as we've heard and seen on TV, hearsay, kept out by hearsay, or lack of foundation, or all kinds of rules that are in the California Evidence Code or in federal court, the Federal Evidence Code. And those objections might mean that testimony doesn't get offered at trial. But here's the thing. If the lawyer didn't lodge those objections at the deposition, then the other side will have an argument that, Judge, those objections are now forfeited, that they can't use that objection at trial because they didn't object at the time of the deposition. So, lots of times when a question is asked, the lawyer will object and will sometimes say, for the record, we're objecting. And we're objecting because we know that later, if we get to trial, we're going to argue to the judge that testimony should not have been allowed at the deposition. But at the deposition, we don't have a judge present. We don't have a judge who's going to rule on our objection. So we make the objection to preserve it for the record. So later, when we go into court at trial and we want to keep that testimony out, that we've lodged the appropriate objections. It can be very disconcerting for a witness because you're asked a question and now a lawyer will put an objection on the record, and the lawyers will sometimes argue on the record about whether that question is appropriate or not appropriate. And the poor witness, it's like watching a ping pong battle. They keep looking back and forth and back and forth. And the witness isn't really sure what all this is about. And then the witness will be told, you can answer the question or don't answer that question. You'll be instructed by your lawyer. And the witness will be confused as to what just happened. So for the most part, your lawyer is placing an objection on the record so that later at trial, the lawyer won't be deemed to have forfeited that objection, and the lawyer can argue the objection in front of a judge. We call it preserving the record. Now, for the most part, once the lawyer lodges the objection and say, you're my client and I object, I'm going to then say, okay, you may answer the question because I preserved the objection and now the other side is allowed to ask you that question. Occasionally, you will be asked questions that are just outright improper, and they might, for example, violate rules of confidentiality. So let's say the other side asks you something that you've discussed with your lawyer. If you've been with your lawyer and you've discussed that in confidence, nobody is allowed to ask you about discussions you had with your lawyer. Those are privileged discussions. So now, if you're asked about something that would be a privilege, it might be a medical privilege, a HIPAA privilege, or an attorney-client privilege, or a therapist privilege, your lawyer is not only going to object, but your lawyer is going to instruct you not to answer that question. Why? This time is the lawyer saying, don't answer the question, where previously the lawyer objected and said, you can answer the question. This time, it's because it's privileged information. And if you answer it, well, now you've just revealed the privilege. And the other side got to hear information that they weren't entitled to hear. So sometimes your lawyer is going to object and instruct you not to answer a question. And that's because the lawyer's worried about privileges and worried about you saying something that you shouldn't say and that the other side is not entitled to know. Generally, the thing is, I will talk to my clients about this and I will say, just slow down. Don't answer until all of the kind of back and forth with the lawyers and the jockeying between the lawyers is done. And know that I know the evidence code inside and out. I used to joke that I slept with the evidence code under my pillow. I actually literally did that, I would fall asleep at night in bed reading the evidence code. Good lawyers that litigate for a living, they're as familiar with the evidence code as they are with the back of their hand. So your lawyer being familiar with the evidence code will guide you in terms of what you should answer and what you shouldn't answer. And you then listen to your lawyer, and that's what's happening with regard to objections. Again, it can be a confusing thing, but mostly the lawyer's trying to preserve the record so that later they can argue the appropriateness of those objections at trial. Before I get to the slide on correcting mistakes, I want to talk about what happens if you're in a deposition and you're asked a question that really throws you. Let's say you're in that deposition and you're being asked questions and you're doing what I've advised and you're being careful to answer the question yes or no. And then if it's a question you need to give more detail, that you're explaining the detail and you're giving a reasoned answer. But let's say you start getting into a situation where it's an uncomfortable area for you and you're feeling that you might say something that you'd later regret, or perhaps you're not really up to speed on this area. Let's say it's a document that you didn't discuss with your lawyer, and you're shown a document, and the document is thick, and you simply don't really remember the circumstances of this document or the circumstances behind what you said. What do you do in that circumstance? I always tell my clients that, listen, if the wheels come off, as it were, if the train goes off the tracks and you're starting to feel very uncomfortable, we are going to pause the deposition and we're going to take some time outside of the deposition meeting room with you and I to talk about that. Now, the rules of a deposition are that when you're being asked questions, you're not allowed to start whispering with your lawyer and talking to your lawyer about the answers you're giving. So one of the things I love about a deposition when I'm conducting a deposition is it's you and me, and you and I are going to go at this, and your lawyer has absolutely nothing to do with this question and answer session. It's you and me, and I'm going to drill down and get everything I need to get, and your lawyer is not part of any of that, which is great. But when it's on the other side, you can start to feel intimidated that while your lawyer is there, your lawyer can't interject more than objections, but your lawyer can't say, hey, you and I are going to talk about this. So what do? If the deposition has been going on for a while, and very often it has, it's 30 minutes, 40 minutes, you are allowed to take reasonable breaks. And I'll often say to my client, it's perfectly acceptable to say, I need to use the restroom here. I need a break. Or I've been going for a long time and I'm feeling a little lightheaded, or I'm feeling a little overwhelmed. I need to take a break. And it's perfectly acceptable to say, I need to take a break. And so I will talk to my client ahead of time, and sometimes we'll have a thing we're going to, listen, if you're really in hot water, then I want you to say, it's time to take a break. And many times it is. You've been going a long time. You're feeling exhausted. You're feeling overwhelmed. You're simply going to say, I would like to take a break. Now, a lot of times lawyers will say, if you need to take a break, that's fine. But I would like you to answer the question before you take your break. And so do you have to do that? Again, it depends on the circumstances. If it's a question that can be answered yes or no, or it's a fairly straightforward question, then if you don't answer that question, and you should have, then at trial, they get to point out the fact that when I was asking you those questions, you didn't answer that question. You sought to take a break. So this is something you have to be careful about. But I would much rather my witness say, we've been going a while. I'd like to use the restroom. I'd like to take a break for 15 minutes so I can settle down, get a drink of water, and relax, and then we'll come back. And as a lawyer, I jump in at that time and go, you know what? I need to use the restroom as well. I need a break as well. We've been going at it a long time. Now, when you take your break, your lawyer's going to be there with you. You're going to go into a different conference room, and we're going to discuss what it is you're concerned about. And then when we come back to the deposition, can the other side go, what did you just talk to your lawyer about at the break? Can they do that? No, they cannot, because the communications you've had with your lawyer are privileged communications, and the other side doesn't get to inquire about that. So I would much rather have my client take a break, familiarize ourselves with the area that we're going to be asked about, talk about reasoned answers, and then come back into the deposition, then start offering wild answers that might not be the truth or might be speculative, and then later will come back to haunt us at trial. Okay? Now, question comes up all the time, should I tell the truth at a deposition? Am I supposed to be going in and telling the truth, the whole truth, and nothing but the truth? And the answer is unequivocally yes. You are under oath. You are to tell the truth. Nobody in our law firm would ever advise people that we don't want you to tell the truth. And so at a deposition, you are expected to tell the truth. Now, again, telling the truth is important, but volunteering things or giving them additional ammunition or going off into an area that you thought you were going to throw into that deposition and you were going to go off in an area that your lawyer never wanted you to go off on, that's different. That's a different thing altogether. So one of the things I tell my clients is, look, in medicine, they have a Hippocratic oath, first do no harm. We're going to do the same thing at your deposition. First, we do no harm to your case. And so there's a lot of gray areas there. That's not saying don't tell the truth. That's saying we tell the truth, but we put the emphasis on this case where we want the emphasis to be. So what does that mean? That means in almost every divorce, actually every divorce, there is a narrative. One party has their narrative, their story. This is what this case is about. And the other party has their narrative. This is what this case is about. A good law firm, a good lawyer tries to grab the narrative and tell our narrative. This is what we want the judge to conclude this case is about, and we want the judge to see that case from our perspective. We want the judge to feel our pain. We want the judge to realize what the other side, what the narcissistic spouse is doing to us and what they're doing to twist and fabricate and convolute this case. So I always tell our lawyers, one of the things we have to do is control the narrative and make sure that narrative, that case, what that case is about is our narrative. And so when we go into our deposition and when we're answering questions at the deposition, we want to make sure those questions are answered along our narrative. Conversely, when I'm going in and deposing the opposing party, you can damn well bet I'm drilling down so that I'm questioning and impugning or impeaching, these are fancy words we use to mean undermining their narrative, so that in the end, it is our narrative, our story, our theme that the judge grasps onto as the theme that makes most sense, as the theme that's most credible, as the theme that most comports with California law. And so that narrative begins from the moment the client retains us, but certainly that narrative is very important at the deposition. We've covered most everything we need to talk about. I want to just conclude here. At the end of the deposition, the court reporter will prepare a transcript of the deposition. And that transcript could be very lengthy because, as I say, many of my depositions go 7 hours. So that deposition might go over the course of an entire day, or it might be on multiple days, because very often I do take 7 hours with my depositions. So at the end of a deposition, transcripts are prepared. And then if it's the deposition of, if it's your deposition, if a lawyer has been deposing you, as a matter of California law, get to review the deposition, and you should, and you get an opportunity to make any corrections to the deposition that you wish to make. Now, we have to be careful. Here again, we have to be careful. If you're making corrections because when you read the deposition, you said perhaps there were 20 pieces to that situation and there were only 19, and you're correcting minor things that are logical to correct, but you want to be precise, then we want to make those corrections, and we will make those corrections, and you should make sure you read the transcript. Every so often, court reporters will actually get the word wrong or the spelling wrong, or they'll write something that isn't the way it was said. And so we want an opportunity to look at the transcript and make those corrections. But we want to be careful. We don't want to say, when I testified that way, I really was totally wrong, and it really is this way. If we're going to make what we call material corrections that are going to change your testimony, well, we need to be aware again that the other side would have an opportunity to say, sir, you changed your deposition testimony, didn't you? You corrected it, but when you corrected it, it became completely different than the first time you gave your deposition testimony. So even with corrections, we need to be very careful, and we need to discuss that with our attorney and be very strategic. We use that word a lot in our law firm, strategy, strategic, in terms of whether we're going to do that. So I encourage you, absolutely, make sure your lawyer shares that deposition transcript with you. Make sure you review it, but then make sure you discuss with your lawyer whether you have any corrections. If it's the other side's deposition, you're not going to get to correct that. They do. But again, you want your lawyer to get you that transcript of the other side's deposition. In our law firm, we do a summary of that deposition transcript, and we do a very thorough line-by-line summary of the deposition transcript from the other side. And the reason I do that is in trial, I'm going to be pulling up that deposition and flipping back and forth and saying, sir, you testified to this at that time, and then let me show you this page and that page. So I have to have a thorough index of that deposition so I can be smacking that witness with their testimony and impugning that witness, and things are happening so fast because we're precise and we're organized and we know the topics of the deposition, so I can quickly be calling on those topics to impeach the witness at trial with that deposition transcript. Of all of our tools that we have in terms of discovery, in other words, of all of those things that a lawyer can use to advance your case, and those things are, remember, requests for admissions, interrogatories, all of these special pleadings we do that our lawyers are very often involved in and answering the questions, which is why those things are often not as useful as a lawyer as I'd like them to be, because the lawyer has answered those questions and there's a lot of objections and a lot of legalese. The deposition is not that. The deposition is the witness and the lawyer. And when we are deposing the other side, that is a great opportunity for us to advance your case, to learn the areas of the other side's case that we can exploit and that we can control the narrative on. And so we want to take full advantage of that deposition and be on the offense with your case. Conversely, when you're deposed and you're the subject of that inquiry and you're getting asked that 5, 6, 7 hours worth of questions, we want to make sure that you're prepared, as we talked about on the video today. We want to make sure you understand the process. We want to make sure that you don't go in there and, as the doctors talk about, first do no harm, that you don't go in there and do harm to your case because nobody took the time to explain to you what's going on in that deposition, what the other side is trying to do, making sure you're prepared and making sure that your credibility is preserved at that deposition. Ultimately, the deposition is a very effective tool to either settle your case, because I can say to the other side, your witness is going to be killed at trial, given their deposition testimony. In fact, it's very often in a settlement letter, I'll put pieces of the deposition testimony into the settlement letter to say, look, you either settle this case on our terms, or this is what you have coming, and I'm going to strip the bark off your client at trial, and your client is going to look very bad, and we're going to win this case. So we use the deposition testimony as a sword to get us the settlement we want to get. And if we can't settle, then we're going to use that deposition testimony at trial very effectively to impeach or undermine their credibility, their case, and bolster your credibility. In other words, we're going to use that deposition to control the narrative of our case. And a good lawyer will know how to do that. A good lawyer will effectively use that deposition as the greatest weapon we have in cross-examination. And a good lawyer knows the value of that deposition. So I hope this was helpful, and I wish you the very best at your deposition. You can get through this. I thank you very much for listening to the video. If you enjoyed what you heard and you'd like to get more videos, I would encourage you to subscribe to our YouTube channel. We make regular videos on all areas of both family law, complex legal issues, and I invite you to subscribe to our channel, and you'll be able to enjoy all of those videos. Thank you very much.